two things have dawned on me this morning. One is I'm a decade older than Emerald, so any minute now she's going to be making the same cruel jokes about me. And also much of what Neale was saying kind of rings true to me. So I've seen, in the almost 10 years that I've been practicing, I've seen so many changes in family law, particularly legal aid. I used to have a very big legal aid caseload until 2014 when the government reduced the scope by about 75%. And I remember even when my clients ticked all those boxes, I would be going down to court and doing the initial hearings knowing that I might not get paid for them. So I've seen an awful lot of changes in the time that I've been practicing. But I will take us on from 1973 and to the brave new world of modern families. And I think this image really shows how family life has changed. This is Modern Families, the TV show from America, which really shows that families come in all shapes and sizes nowadays. We've really changed the way that we're living, and is the law keeping up with it? So everything that I'm going to be talking about this morning is the law that I've been practicing really in the 10 years that I've been qualified, so the legal landscape as it is now. So if we start with cohabiting couples, because we know that they are the largest growing family type, but what do we know about their legal and financial protections? Now, as Neale says, there is no such thing as a common law husband and wife, and there was one time when that was almost a weekly occurrence of someone would come in to see me and be absolutely devastated when I would tell them, I'm really sorry, but as an unmarried partner, you have no rights to property, rights to pensions, things like that. More recently, I'm not sure if it is coming up quite as much. And I wonder if it's because some of these headlines, perhaps people are beginning to realise that things aren't quite as it seems if you are just living with your partner without getting married. But what does the current law let us do to protect ourselves, to protect our partners, and to protect our kids? So the first thing that we can do is we can enter into a cohabitation agreement. But the first thing is we need to know about them. And not that many people know that this is such an option for them. And they both have to want to enter into it as well. There's nothing automatic about it. So a cohabitation agreement is a document which sets out how you're going to run your finances together, anything else really that you want to put in there. And importantly, it can also cover some of the things that you might want to happen if the relationship did run its course and come to an end. But what it can't do is deal with pensions in the same way that we might want to, so there are limitations with that. If we're buying a property together, it's very important we know about declarations of trusts. So if we're buying a property together and perhaps one person's putting down the deposit, the only way to protect that interest is to actively agree to enter into a declaration of trust. Without that document, if you were later to break up, there's no easy legal way of making sure you get your deposit back. We have to enter into the realms of the Trusts of Land and Appointment of Trustees Act, which we call Talata, to try to make a claim to say that we should have this increased share or this beneficial interest if we're not a owning partner.
So where does the tenants in common come into?
That's if you're buying jointly. So if you're buying a property together, we've got two options. We can either buy as what's called joint tenants, and the legal implication of that is if one of you passes away, that their share of the property automatically passes to their partner. But particularly with unmarried couples, as I say, particularly if contributions are unequal, the advice given will be to be a tenant in common, which means you have a distinct share each. The presumption is 50% if you don't have a declaration of trust. And then that share of the property will pass by that person's will or through intestacy, so it won't automatically go the other way. So that's the really important distinction, and that's where declarations of trusts become incredibly important, because without that, there's no legal protection for an increased interest. Okay. If you have children together and you separate, you can make an application to the Child Maintenance Service, which used to be the CSA, to get some child maintenance. Or if the non-resident parent is very rich or living abroad, an application can be made under Schedule 1 of the Children Act. Now, that's quite time-consuming and it can be expensive, but it can be worth it to an extent because the court has the power to grant kind of an interim capital award. So the court could say to non-resident parent, you've got the resources to buy a house for your child to live in until that child reaches 18. They can live there with resident parent. And once the child is 18, you get the house back. So for the parent who's looking after the child, there's no financial security with that, but at least it keeps a roof over your head for the kid while they're young. So they're not perfect solutions. But what we need to bear in mind that nothing about this is automatic. If you're going to enter into any of those things to provide yourselves with some protection, they have to be active steps and you both have to agree them, because otherwise there is no automatic financial rights. There's no automatic right of inheritance. It can be a very long and expensive claim under the Dependents Act. No rights to pension, no rights of occupation if you're not on that tenancy or if you're not on the deeds. So what is the law doing about it? To be honest, not an awful lot. And I think it's because of this question. Neale was talking about this earlier, and already we've got two very opposing views in the room. Because should cohabitees get financial rights, and if so, when? We've already, had a discussion this morning that that's an incredibly hard decision to make, what the conditions should be for any automatic rights to kick in. Because I think importantly, what if you don't want to give each other rights? What if you do actually want to stay very independent financially? Lots of couples do choose to do that. And another reason why the government and the law courts might be a bit reluctant to start imposing something is because there is an option to get rights and to get responsibilities, and that's to get married or to enter into the civil partnership. So why should the government waste their time on it when there is a relatively easy route nowadays in order to formalise a relationship? But the courts are tentatively stepping into this area and is making some decisions which indicate that they are willing to consider cohabitees' rights. And this is the first case. This is Denis Brewster. It's a Northern Irish case, but it does apply to us. So Denise was in a relationship with her partner Lenny. It was a long relationship. They were together for 10 years. And on Christmas Eve, back in 2009, they got engaged. On Boxing Day, Lenny died, suddenly and unexpectedly. He wasn't very old. I think he was in his 30s. Now, Lenny worked for a local authority and had a very decent pension provision. Had Lenny and Denise been married, Denise would have automatically received a widow's pension under that scheme. Because they weren't married, Lenny would have had to have actively ticked a box in a form for Denise to receive those same benefits. And he hadn't got around to doing it, in the same way that lots of people don't get around to doing an awful lot of things, including making wills. And Denise said, "No, that's not fair." Denise said, "I'm being discriminated against because I'm not married. I wasn't married to Lenny when he died." So she made an application to the court on the basis of discrimination, and it reached the Supreme Court, who agreed with her. So she was then entitled to the widow's pension. Now, I was quite surprised by that decision. Not to say that I don't think she should have had a benefit from that pension scheme, but is being married a class in and of itself that can be discriminated against? Because ultimately it's a choice. It's not something that you're born with, as colour and race and sexual orientation is. It's something very different. And actually, this hasn't been particularly far-reaching. It hasn't been a decision that's kind of revolutionised the world, but perhaps it was an indication that the court was prepared to consider it. The next case is the case of Rebecca Steinfeld and Charles Kayden, who decided that they did want to formalise their relationship, that they did want to give each other financial rights and securities, but they didn't want to get married. And I've heard people say lots of, quite compelling reasons as to why they might not want to get married. Often I hear it's patriarchal, it's so rooted in such a kind of sexist system, or it's so religious that I reject that and I don't want to go into that state. Although having said that, civil ceremonies are, very, common nowadays. So they said, well, we want to formalise our relationship. We don't want to get married. We'd like a civil partnership, please. But at that time, you can't enter into a civil partnership unless you're in a same-sex relationship. So they sued on the basis that they thought it was in breach of the European Convention on their Human Rights. And again, that went all the way up to the Supreme Court, and the Supreme Court agreed with them. So as of this very month, straight couples can now enter into civil partnerships. So that's a very, very recent thing. But what are civil partnerships? Well, civil partnerships, for all the limitations on it, was revolutionary. It was a huge, huge step forward in family law because for the first time ever, the law legally recognised same-sex relationships. So same-sex couples could enter into a civil partnership. It gave them exactly the same rights and responsibilities as straight couples who got married. They had the same property rights, same rights of inheritance, tax benefits, pension benefits, and they could become each other's next of kin. But did it go far enough? And was the very idea of it, was that inherently discriminatory? Well, lots of gay couples were saying, why are you giving us this second tier relationship? You're still marking us out as separately, and that feels wrong, and that feels unfair. And Charles and Rebecca thought it was unfair because they felt that they were being excluded from the opportunity to formalise their relationship in the same way. So there was some deep thinking and some consideration of that. And in 2013, we got the Marriage Same-Sex Couples Act. So this brought in equal marriage. We call it the Equal Marriage Act. So same-sex couples can marry. If they'd already entered into a civil partnership, they can convert their relationship from a civil partnership to a marriage. But not all things are equal. If the relationship breaks down, a same-sex couple can't rely on the fact of adultery to start their divorce or their dissolution. And that's because of the legal definition of adultery is a relationship with someone of the opposite sex. So that's not allowed. And then pensions. We all know how exciting pensions are. But this is a very interesting case. This was a case of Mr. Walker who sued his pension fund. So Mr. Walker was in a relationship with his partner. They entered into a civil partnership, which they later converted into a marriage. And Mr. Walker learned that his husband, because of an exemption in the Equality Act, ironically, that his husband wouldn't be entitled to the same benefit under his scheme as his wife would had he married a woman. And it was a huge difference. Mr. Walker's husband, under his pension, would only be entitled to £1,000 per annum. If he'd have married a woman, his wife would receive £45,000. So that it's quite obvious, it doesn't sit right, does it? So he went to court, again, all the way up to the Supreme Court Act, and the Supreme Court Act said, of course, it's incompatible. So that exemption in the Equality Act is to be disapplied, so everyone's on exactly the same equal footing. So Mr. Walker's husband will be provided for properly under the pension if it came to it. Right, so 2004 was quite a revolutionary year. We had civil partnerships, and then we also had the Gender Recognition Act. And the Gender Recognition Act allowed for the first time someone who is transgender, so they identify as a different gender to that they were born with, could apply for a gender recognition certificate which would legally change their gender. So on their passports, on their driving licence or their official documents, it will be their chosen what they feel to be their true gender. So as family lawyers, we have to consider the impact of that on marriage. And it's quite complicated. So I will try to get my head around it as I talk about it. So if there's a couple and they are married and one person transitions to their chosen gender, before 2014 they would have had to have ended their marriage, because before the Equality Act, two people of the same gender can't be married. So that had to be it. There had to be a divorce after that. After the Equal Marriage Act, as long as the other spouse consented to stay in that marriage, it could continue because we had equal marriage. Before that, they had to consent to go into that. Now, civil partnerships. So, if a trans woman, male at birth, was already in a civil partnership with her male partner, before Rebecca Steinfeld and Charles Kayden came along and changed the law on civil partnerships, so opposite sex couples can enter into it, again, they would have had to have ended their relationship, because at that time, opposite sex people couldn't be in a civil partnership. But now, as of May 2019, presumably the same rules will apply. So as long as the other partner consents to stay in that legal relationship can continue. Right. Let's move on to the farmers. Now, farming families have made two of the most revolutionary changes in family law over the past 20 years or so. And they've really changed the way that we operate. And the first case is in respect of matrimonial finances. And it's the case of Mr. and Mrs. White. So if you speak to any family lawyer nowadays about matrimonial finances, they will run out a very well-rehearsed spiel that they can say in their sleep, that when we're looking at family finances, the starting point is 50-50, but we are entitled to look at all the circumstances of the case to decide whether or not we need to depart from that. I say that 100 times a day. And the reason why I say that 100 times a day is because of Mrs. White and what she did. So Mr. and Mrs. White were a farming family. They got married in 1961 and separated in 1994, so it was a very long relationship. 3 kids, so when the kids were young, Mrs. White tended to stay at home with them, but she was very involved in the farming business. The business doubled in size during the course of their marriage, and by the time all this came to court, the assets were worth over £4 million. So when it first went to court for the judge to decide how to divvy up all the money, the judge thought, okay, well, what does Mrs. White need? She needs a house to live in. That needs to be mortgage free. She needs some paddocks because she's got some horses. And round here, that will cost her X amount of pounds, and we might give her a bit more to meet her needs. So all she needs is £980,000. So Mr. White keeps over £3 million, and off she goes. Just because it meets her needs, she can just have £980,000. And she said, oh, that's not fair. Why should I walk away with a fifth of our family assets when I've been just as involved in this marriage, and I've been just as involved in raising our family and growing the business? So she appealed, and it went to the Court of Appeal, and they said, yeah, that wasn't really fair. We'll give you £1.5 million, about 2/5. That'll be enough for you. That recognises your contribution. And again, she said no. On what logical basis is that? So it went all the way up to the House of Lords, which is now the Supreme Court, and they said, yeah, 50-50. That should be the general guide, and we should only move away from that if there's really good reasons to. So that really did change the way that we were looking at it. It wasn't just looking at one party and saying, well, that is all you need, so that's all you're going to get. No, if there's more than enough to go around, starting point is 50-50. And then just a quick mention of the case of Mills and Mills, which is about spousal maintenance, and it's the end of the meal ticket for life. That was all in the press. So it's basically there's been a sea change at court away from spousal maintenance. The court wants everyone to be as financially independent as soon as possible. So we don't really see joint lives orders for spousal maintenance anymore. If there is a claim for spousal maintenance, then that tends to be time limited, or we might look to capitalise it or something like that. And it was quite an interesting case because Mr. and Mrs. Mills separated, and she received enough capital in the divorce to rehouse herself mortgage free. And then she got some spousal maintenance for joint lives on top of that. And then she made some really quite bad property decisions and lost all her capital and racked up a huge amount of debts, which she then struggled to service every month. So she went back to court to say, I need some more money out of my ex-husband every month to help me service my debts. And he said, well, that's not fair. She had a capital. What she did with it was her fault. I don't want to pay any more. And the judge agreed, so he didn't pay any more. So we now all know to move away from spousal maintenance. So the other big development in matrimonial finances are prenups. So we've all heard about them, and more people are coming to see us to talk about them. And often it can be couples who've perhaps been married before, who've been divorced, who've had to sort out the family finances under the Matrimonial Causes Act. And thanks to Mrs. White, we know starting point is 50-50, but there are all these circumstances that we look at, and that means every outcome is going to be different, so we can never give people certainty about what they might try to achieve if a relationship were to break down. And people might not want that, having been through it before. So a prenup is a means of protecting assets to protect children. There can be children from previous relationships. And it's also taking back some control to decide for themselves how they want to sort everything out. It contracts out of the Matrimonial Causes Act. And the case that has given prenuptial agreements weight is the case of Radmacher and Granatino. She was German, hence my little pigeon, and he was French. And they got married in Germany, where prenups are legally binding, but then moved to the UK, and then they broke up. So the forum for the divorce was the English courts, and Mr. Granatino said, brilliant, because of Mrs. White, I get to have half, and we don't have to stick with that prenup. And she said, no, the court should give weight to that. He knew exactly what he was entering into when he signed it. They are binding in Germany. Why? Just because, well, at the moment we can live anywhere we want in Europe. I don't know how much long that will last. Why should the rules change suddenly because we're living in a different jurisdiction? And the court agreed with her. The court said, we will give effect to a prenup as long as it was freely entered into, so no one was piling on the pressure the day before the wedding. Everyone knew the implications of it, and that it's still fair to uphold it. So that gave us 3 overriding rules when we are drafting prenups. The first is it should be entered into in plenty of time before the wedding. We get phone calls saying, I'm getting married in a fortnight, please can I have a prenup? And we want to tear our hair out because we'll do it really, really quickly, but we'll say you need a post-nup too, because there could be, we don't have enough time. Full and frank disclosure, you need to know exactly what each other has got before you enter into a prenup, because if not, you've got one eye shut. So you need to know exactly what you're entering into. So, and by doing that, you need to know what each other's got. And both parties need to have independent legal advice. So if any of those tests fall down, that's really undermining the efficacy of the agreement. So we want to make sure that we tick all those boxes. Right, so what is the future of family law? I'm really excited about the outfits. I'm looking forward to that coming in. Well, divorce. As Neale indicated, we are on the cusp of a revolution, we hope, in respect of divorce law. So this law is over 40 years old, and when we are doing divorces, the vast majority of the cases I do go ahead on the basis of number 2, unreasonable behaviour, because more often than not that is the only one that applies. People don't want to live apart for 2 years often. They want to sort everything out more quickly. Adultery is not often relevant. So our hands are tied, and we have to advise our clients that in order for them to achieve a divorce, it has to be based on their soon-to-be ex-spouse's unreasonable behaviour. And what that means is us telling our clients to come up with about 5 reasons as to why they were tearing their hair out with their partner's behaviour. And the reason why this doesn't sit particularly well with us now is that the vast majority of family lawyers are resolution, and we believe in a constructive approach. We want people to stay friends at the end of this, particularly if there are kids. So we want to try to reduce the tension, not increase it. So we say to our clients, look, let's be amicable, let's be collaborative. And then we have to say, but give me these reasons, which really have to poke them with a stick. So it's really at odds with each other. But back come the farmers, Tinny and Hugh Owen, who are mushroom farmers. And Tinny is the lady, if you agree with no fault divorce, that we need to thank for it. So she was denied a divorce from her loveless marriage, from her partner, her husband Hugh. She applied for a divorce, had to be on the basis of his behaviour because they hadn't been separated for the requisite amount of time. And the reason why we know about this case is because her husband Hugh made the decision that he was going to defend the proceedings. Now that's incredibly unusual. Most people accept the writings on the wall if their spouse has drafted a divorce petition and the proceedings go through, but not Hugh. Hugh felt that they still had a few years left to enjoy, so there was a full contested hearing. The district judge in the first instance decided, having heard the evidence, that he didn't think that Mrs. Owen's grounds were quite sufficient for the divorce to go ahead, which he was entitled to do. There's so much discretion in family law. He felt she hadn't quite made her case, so denied her the divorce. She appealed it because she was quite determined that she would get her divorce, thank you very much. And that went up to the Court of Appeal and then the Supreme Court. Both courts had to say that the judge did nothing wrong in coming to that decision. They might not have agreed with it, but he didn't do anything wrong, in which case Tinny had to stay married to Hugh until 2020, when she can apply for a divorce on the basis of 5 years, which doesn't require consent. So the Supreme Court weren't particularly happy about it. They were saying that they had to dismiss her application, but Parliament may wish to consider whether to replace a law which denies Mrs. Owens any present entitlement to a divorce. So we all started shouting about that, and the government listened. So it's even reached all the way to Grimsby. They're even reporting it. So we are going to get no-fault divorce, apparently. So the Justice Secretary, David Gore, confirmed that in the next parliamentary session he will be bringing in legislation to provide for no-fault divorce. Now we're still awaiting on some of those details, but what we have heard is that it's going to remove completely the need to apportion blame, which for practitioners, particularly when there are kids involved, we feel that that's going to be helpful, that it's going to kind of ease the way in what's already a very difficult situation, for people to then go on and hopefully stay friends at the end of it. We've heard that it might even be able to do it on a joint application. So we have, at the moment, we have a petitioner and respondent, and people sometimes have very strong views on that. I really don't want to be a respondent, or I'm the petitioner, therefore I must be right, which isn't what the law thinks. You can't defend it anymore. So most judges, lawyers and the public think that it is a good idea, although some people don't. Some people think it's making divorce way too easy, that it's kind of reducing the significance of marriage, which isn't a good thing. But that is a big debate for another day, so I won't bore you with that one. So I will now hand you over to Emerald, who's going to cheer you all up by talking about death.